All rise. The Court of Appeals, Division 1 is now in session.
Good afternoon. Please be seated. Thank you. This is the time set for oral argument on our case captioned Barbara Lawal versus R.R. Robertson, LLC and others. Case number 1CA CV140367. Each side is allotted 20 minutes. Counsel for appellant, if you wish to have some rebuttal time, it's up to you to watch the clock and tell us when we get there where you'd like to sit down. We'll try to honor that and leave you a few minutes if you want to do it that way. If you would both, whoever's arguing, state your name for our recording when you begin, that will be helpful as well. We have reviewed the arguments and issues and conferenced the case, and I think we're ready for your argument. Please proceed.
Good afternoon, and may it please the court. My name is Andy Flagg. I'm a deputy Pima County attorney. I'm here on behalf of the appellant, Barbara Lawal. Unlike probably the lion's share of public records cases that this court sees, this case is not about whether a member of the public can access a public record, whether a particular document is in fact a public record. It is instead about the cost, or whether the requesting party must pay the cost of producing records that everybody agrees can be furnished under the statute.
The documents have all been identified and produced already.
That's correct. After Judge Brain's ruling, we produced the documents to both R3 and to Mr. DuPont. So it's not about whether the documents will go out the door. And the one minor field that we redacted, dates of birth for the defendants, has never been an issue throughout this case. Any public records request requires cost to respond to. It requires if it's papers, the mechanical cost of copying. If it's digital data, it requires the media that the data is recorded on. It requires staff time. In this case, staff time necessary to produce the query necessary to pull out the responsive data.
If I understand your point, it's that the question is whether you get to charge a reasonable fee, which would normally be the case, or whether in addition you can, the public entity can also act under subsection A of statute, which says that the portion of the cost for obtaining the records, a reasonable fee, the value of the reproduction in the commercial market as best determined by the public body. Is that right?
That's basically correct, Your Honor. I think that general non-commercial request, we don't even charge for, and I don't think we're allowed to charge for staff search time. It's really just the cost of reproduction. So that additional component, the time necessary to search for and obtain the records, is a component that is unique to commercial requests, and then the value of the record on the commercial market. Those are really the two components that are at issue in this case. And I would submit that what the legislature has done with 39-12103 is to set up a system where for non-commercial requests, all of that cost but for basically the mechanical cost of reproduction is spread to the taxpayers at large, because the public records statutes are about transparency in government and the ability of members of the public to access what the government's doing. But in the context of commercial requests, where requesting parties are profiting off, to use the language of this court in Star Publishing, the direct economic exploitation of public records, what the legislature has said is that the taxpayers are not to subsidize the cost of complying with that request. And so those additional items, the cost of staff time necessary to search, redact, obtain, et cetera, the public records, and the value of those records on the commercial market is then paid by the commercial.
The issue here is under the last sentence of 39-12103D. Right? That's really the key.
That is the primary issue in this case, Your Honor. There's some argument in the briefing about the commercial purpose definition. The first sentence, the producing a document, I think it's quite clear with respect to R3 that their use falls under that first sentence of subsection D. It's quite frankly, not clear with respect to DuPont, and that's why we withdrew our cross motion below. So that issue,
But the real question is D.
Correct.
This last sentence.
correct. The real question is what's been called the evidence exception by all the parties in this case, the last sentence of subsection D. And what R3 and Mr. DuPont are asking this court to do with respect to that last sentence of subsection D is to read basically two provisions out of that sentence. That's the phrase "in an action" and the word "evidence."
Well, okay. But as I read it, it's sort of the issue is, does action mean pending action? And does evidence mean that it has to be admissible? Is that the crux of the dispute between the two parties?
I disagree slightly as to the pending action issue. Certainly, we think pending action is the most sensible way to interpret this statute, but R3's position takes it even out of the context of there needing to be any action contemplated. So R3's use of the records is basically R3 stores public records in a database. It then, when a client comes along and wants to buy a sentencing analysis report, it puts in whatever parameters the client requests and pulls out a responsive document and produces
Is that what
that.
a squirrel request is?
I've heard it called SQL, Your Honor.
SQL?
Maybe I haven't heard squirrel, but perhaps that would be another.
It's okay. So it's that, but that's sort of, it's a mask, which says here's the sort of the items or the categories we want, and it then takes the data out through that.
On my admittedly limited technical understanding, yes, Your Honor. That is my understanding of how it works.
Technical geeks out there, they'll be laughing at both of us. But go ahead.
And Your Honor, I would submit that in at least a lot of the cases, that's where R3's use of the data ends. The report is then used by the client, and this is clear from the record. It's something that R3's been frankly very candid about, that the client, be it a criminal defense attorney or a criminal defendant, can then use the resulting report in whatever manner they see fit in defending a case. R3's use of the records to store it for perpetual production of these reports is not only not limited to a pending action, it's not limited to any specific contemplated action at all. And so when I say that R3 is asking this court to read the language "in an action" out of the statute, it's not just pending action, it's that the request does not have to be tied to any action at all. So there are some hypotheticals thrown around in R3's briefing and in the amicus brief from the Arizona Attorneys for Criminal Justice about pre-action requests. And again, I think we've taken the position that pending action makes the most sense for a lot of reasons, which I can get into, but at least in those hypotheticals, there's a party contemplating bringing an action, or there's the government contemplating potentially investigating, for example, somebody for potential criminal prosecution. In those instances, at least there's an articulated, contemplated action in which the record or the product of the records could be used. R3's use is completely divorced from that. There's no tie to any action at all, pending or contemplated. So I think that's the crux of the issue with respect to "in an action." If the court, I don't think, frankly, needs to even reach, at least with respect to R3, the issue of whether the action must be pending or not. Now, we've provided a number of examples in our brief of statutes that use the phrase "in an action" or "an action" in a way that that indicates that it really can only apply when there's a pending action, and I think, quite frankly, this statute is most reasonably read that way as well. One cannot use something in an action if there's not an action to use it in. So that's why we've taken the position that it ought to be a pending action, but I think R3's position is much, much broader than just that.
What about a pattern of past actions that can be used to predict future actions with some reliability?
I guess maybe I'm not understanding Your Honor's question, but is Your Honor referring to perhaps the contemplation of a civil action based on prior sentencing disparities or something along those lines?
Possibly.
So in that case, the requesting party is at least contemplating perhaps bringing civil litigation. If a party wished to, for example, bring a constitutional challenge to some sort of sentencing scheme, and the argument was, we think we're going to get at these records and we're going to see sentencing disparities based on race or some other suspect classification. That's not a pending action, but at least again, a meaningful distinction from, I think, R3's position in that case. At least that party is requesting the data for a particular contemplated action, and its use of the data is going to be limited logically to that action. R3's
Applied in this case, it was going to be used for contemplated, for a pending or contemplated action, at least in this case.
R3's use, Your Honor, or Mr. DuPont's?
Well,
We,
R3 indicated that it was going to use it, it may hold on to it for other purposes, but that it was going to use it that had a client that wanted to use it for a contemplated or pending action.
I think that's true only of the second request. The first request said, in a very general way, this will be used in judicial actions. The second request said that it was on behalf of a specific client. But in its discovery papers, and this is in the record, R3 has admitted that even if it got the data for the second request, it was going to use it for that was the first-degree murder data.
Yeah, right.
It was going to use it for any case that involved first-degree murder. So, quite frankly, even though the request said it was on behalf of a client, they've been, again, very candid about how they intend to use it. They're going to use it in an ongoing...
Problem, they don't know what they're going to use it for, because once they have the data, then the question becomes, well, who's asking for it? I mean, so right now, all they can say is, hey, we've asked for the data, we're going to keep it in our files, and we have a client who wants, to do this, we're going to use it in a possible action, or the client's going to use it in possible action.
Right. So I think one of the things that makes it possible for all the parties to toss around a lot of hypotheticals in this case is that there is no pending or contemplated action. And so to Your Honor's question, yes, there are certainly a lot of uses that one can conceive of. I think that we know what R3 intends to do in the main with these data, because again, they've been very candid about that, and we know what they do in Maricopa County. They produce sentencing analysis reports for criminal defense attorneys who normally pay a fee for the product, and who then use the product in any manner they deem fit. Again, as I said earlier, that's when...
Requesting, the client's not coming to you saying, let me have it, I'll use it for anything I want. It's R3 that's coming to you, and they're saying they have clients that are going to, that at least in this case are actually going to use it or want to use it in pending or contemplated actions.
That's correct.
Whether sometime, 10 years from now, one of their clients says, oh, gee, I got all this for this case X, which got filed and disposed of, and now I want to use it for a law review article, is something else. But they're not the requesting for it.
Sure, and that's why we've asked the court to focus on R3's use. I think that's what the key issue is, at least with respect, of course, to R3, is that the focus needs to be on how R3 is going to use the data for purposes of determining whether their use is commercial or not how their customers are going to use the data in some, again, to quote from their briefing, I think it was in the trial court, future undetermined case, or future undetermined non-case, to go to Your Honor's example of a law review article. We can spin a number of different hypothetical ways in which a client might want to use it. But if the focus is on R3's use, I think we know pretty clearly what they do with it. They store it in a database. When a client comes and says, I want a sentencing analysis for whatever reason, they take the client's parameters, they run the search, they pull out the report. In some instances, they provided examples where they do more. They go pull the pre-sentence reports. Sometimes R3 might make a sentencing recommendation to the lawyer. But at the end of the day, that's how R3 is using the data. The customers may use it in any number of different ways, and I think it makes this case much more difficult and much more divorced from the statute to try to focus on what the customers do with it and to dream up different ways that the customers might use it that might fall under the evidence exception, not fall under commercial purpose, violate confidentiality, all that stuff.
And the clients aren't the requesters.
That's correct, Your Honor.
In addition to our looking at the words as best we can and using the words as best we can, do you have some other interpretive principles to share with us? And for example, it seems to me one way to look at this, although I think we look at the words first and foremost, but in addition, the legislature has set up a regular fee. I assume that's been paid. They have then set up a greater fee for commercial purpose materials, but they've added this exception at the end of the subsection D that looks looks pretty broad in some ways. And, shouldn't we just interpret that broadly, one might argue? And if that's not the way the legislature wants it and the governmental entities want it, they will go to the legislature and get them to change it.
Sure, Your Honor, and I guess I'll start with a broad interpretation cannot be an interpretation that takes language out of the statute. The legislature certainly could have said for use in judicial proceedings. It didn't need to say in an action, and it didn't need to say as evidence or as research for evidence. So to go back to the words, I guess that's maybe the best principle I have is that the text of the statute is the best and most reliable indicator of the legislature's intent.
We say that often.
This court does, and it also says often that it doesn't construe statutes in a way that renders words within those statutes meaningless or superfluous. And I would suggest that those terms, in particular in an action and the word evidence, need to be given meaning for that reason, and R3's position, frankly, does not give those terms meaning.
Your argument as to evidence is it has to be admissible evidence, right?
That's our argument, at least when the body is the judicial body.
How is either a requester or the public entity supposed to determine whether in a contemplated action all of the data that's being requested or any portion of the data therein will be admissible until the judicial body can rule on admissibility?
I think in a particular case, I suppose it might be difficult, and maybe that's why the research for evidence language is in there, to make it a little bit broader, maybe to extend it to something more like civil discovery, something that's reasonably calculated to lead to admissible evidence. In this case, there has to be, in order for something to be admissible, one of the very bedrock principles is that it has to be relevant. That applies not just under the Arizona Rules of Evidence, but it applies before just about every quasi-judicial body.
But again, how is the public entity supposed to say, well, gee, I'm going to determine that in some contemplated or pending action where I don't know the issues, that the court will rule this is admissible?
Well, we think if there's a dispute as to that, and this gets, maybe part of to some of the other issues that were raised in the briefing, we think it's reasonable to ask what's at issue in the case without requiring disclosure of privileged or ER 1.6 confidential
and then
information.
presumably the county attorney would do research and determine whether it felt it was admissible, and if it was right. And then could say, okay, to get this information, we don't think it's admissible. We don't think it's going to be admissible. So to get this information, you have to pay us for it doesn't fall under the exception, and therefore you have to pay us the value of the information on the commercial market.
Well, we have to show it's commercial first, under the first sentence before we even get to the exception, and we've talked about that briefly here, and I think it's well briefed. So just that it doesn't fall under the exception doesn't necessarily mean we get to charge. So that's one way to answer your Honor's question. But to get directly to it, I think there are a lot of instances where public bodies need to make legal decisions. It's one of the reasons they all have lawyers, I suppose.
But aren't you going to be making yourself a pre-arbiter of what is most likely admissible in a hearing, if we follow what you're suggesting is acceptable?
Well, again, only for purposes of, I suppose, determining the cost of obtaining the public records. We're not talking about whether the records can be obtained and used for that purpose. But somebody has to make a decision. If the public body can't make an initial call about whether something can be used as evidence or research for evidence in an action, then the language is meaningless.
Okay, so the county attorney's office then, in a criminal defense case, might be deciding pre-litigation, before they actually proceed into the action, what they think the defense will need toward the defense of their case that would be admissible, so that they can decide the rate they're going to charge them for the documents?
I think there has to be an initial assessment of whether the documents fall under the statute. When you're talking about the type of data that have been requested in this case, which have nothing to do with the prosecution of any particular defendant.
But wait, you the last request was for all cases involving charging for murder, correct?
First-degree murder, correct, Your Honor.
Sounds to me like somebody was getting ready to tee up a constitutional issue or a likelihood of success evaluation or something in a criminal prosecution.
Well, and if that specific purpose was disclosed, then the county, the public body could look to that and make a determination.
That's a good point. That's a good point. If the statute said that if it's a non-commercial purpose, you have to say it's a non-commercial purpose. But as I understand the legislative history, the legislature took that language out. Originally, you had to say it's what purpose it's used for. Now you only have to say this is for a commercial purpose, and get into the information. So the person coming in, making the request, doesn't have to say anything. It can just say, here's the data I want.
That's correct, Your Honor, but there's also been no dispute in this case, and it was conceded by R3 below in the oral argument, that a public entity can do due diligence in responding to a public records request, and one of those things is looking at the request, looking at what, in R3's case, what R3 advertises on its website as in terms of what it does with public records, looking at a request that came from Mr. DuPont that was effectively a cut and paste of R3's second request.
County attorney says, I want this following information, and the requester says, you're not entitled to it. I'm not giving it to you. So then you get involved in a lawsuit where the county, either the person comes in and sues the county attorney saying, you won't give me this information, I don't have to certify anything, I don't have to tell you what the purpose is, and the county attorney, then you're going to get involved in an expensive discovery between the two parties about what the purpose was when the statute doesn't say they have to give you a purpose.
Your Honor, I think in a particular case, if it leads to litigation, as this case did, then maybe that's appropriate. I think the fact that the statute has been around as long as it has, and frankly the dearth of case law that everybody's recognized on this statute suggests that that's not likely to happen.
Because no other entity has said, and I'm not criticizing the county attorney for doing this, but I'm just saying maybe no other entity has actually come forward and said, we don't think this is a non-commercial purpose. You have to give us reasons. Maybe most agencies just say, here it is.
We're out of time for Mr. Flagg, but we'll let you sum up if you would like, or finish answering Judge Kessler's question.
If I can just finish answering Judge Kessler's question,
please
I would
do.
appreciate it. First of all, one of the reasons this particular issue may not have come up a lot is not just because the Pima County Attorney is the first public body to challenge it, although it is because I think what R3 does, and R3 will probably tell you, is it's a fairly new type of analysis and service that's being provided. And so, yes, it may very well be, and in fact I think is the case that with respect to R3's use, other entities have simply provided the records, and that can be based on a number of factors that go beyond whether that party's right or wrong. So Your Honor is correct. There may be certainly other reasons why the case law is not that developed, but I do think that it's unlikely to lead to a flood of litigation if the public body is simply allowed to ask what the purpose is. Thank you.
Thank you very much. Counsel for appellees.
May it please the court, my name is Dan Barr, and I represent R3 Investigations and Richard Robertson. I'm here with Chris DuPont, who is a party in this matter as well. Your Honors, R3's position in this case is fairly simple. It requests historical charging and sentencing data for a non-commercial purpose under Arizona Public Records Law, and it is deemed to be non-commercial both under the Star Publishing case and under common sense readings of both sentences of ARS 39121.03D. There's no dispute here that R3 does not resell the raw data it obtains, but rather it uses that data in its trader business to create custom reports for the benefit of criminal defense attorneys, for their clients, and for sentencing judges.
It sells those reports.
It sells those reports, but it's the reports, Your Honor, it's not the raw data, it's their analysis of the data. That's the value.
It's clearly a commercial purpose. You're saved, arguably, by the last sentence.
Well, Your Honor, I'll disagree that it's a commercial purpose under the first sentence, but I would agree that under the last sentence that we're certainly safe there.
The only thing we have to decide. I mean, if we agree with you on the last sentence,
Sure. But let me just take a whack at the first sentence.
Okay.
Yeah, you're right.
I've got it here. Go ahead.
Okay. First of all, in the last, during R3's several years of existence, they've accumulated 500,000 criminal cases statewide, from the Arizona Supreme Court, from the Maricopa County Attorney's Office, from the Pinal County Attorney's Office, and they've been used their reports to educate clients, evaluate plea offers, and analyze the disparities in sentencings and charging decisions and the like. Within the last week alone, R3 research was used by attorneys in challenging the constitutionality of Arizona's death penalty before Judge Kramer down the street, and also in the sentencing hearing involving Jodi Arias. We say that under the first sentence of the statute, it's non-commercial on its face. But as the court suggests, that even if there's a dispute about that it's clearly either evidence or research for evidence that's used by courts, litigants, or attorneys, and would say by the second sentence of the statute.
But the reason you're arguing the first sentence is because your clients are not reselling the documents.
That's correct, Your Honor. If we were taking the data and just reselling it to somebody and saying, here, we have all this data, you do this, and then you can do your own research and all of that, that would be a commercial purpose. Just as under the first sentence of the statute, if you take public documents and use it to solicit business from people, you use people's names and phone numbers and say, you call up accident victims or, things like that. That would be a commercial purpose. Here, we're not reselling the data. What we're selling is our analysis of the data.
Understood.
Just like lawyers look at cases and analyze them, and we're selling our analysis. We're not saying to the clients, here are 20 cases, go read them, and we think you'll find the answer in there. The data itself is not useful to R3's clients. It's the analysis of the data. It's not only from the programming, but, applying the, analysis of common sense and experience and all of that. Now, the county attorney claims that the mere use of the public record and for some profit-seeking purpose is per se a commercial purpose. But Star Publishing held otherwise. In that case, this court said that there's a clear line between what they called the direct economic exploitation of public records, which in this case would be selling the data directly, versus the use of information gathered from public records in one trade or business. And that's what R3 Investigations is doing here, is they're taking the data and analyzing it and producing reports to people.
presumably those reports would only have the meritorious use, be helpful in the case if it could be backed up by the data. I mean,
Right.
anybody can issue a report. And
Well-
an attorney could just say, here's my report, here's the report we use, and this shows X. And the court can say, how do we know this report has any validity?
Sure.
And the court can then say, okay, before the report's going to be of any benefit, we need to know the data that's backed it up. It's like an expert testimony.
Or just putting, exhibits into evidence. I mean, it's the difference of if I came into court and I said, here are my 100 exhibits, I put them on the table, I said to the judge, you figure it out. Versus before, taking the exhibits and explaining them and making them into a meaningful format and all of that.
Do that, but if you make it out of whole cloth, the other side can then cross-examine you or cross-examine your expert who's
sure.
prepared the exhibit, the report, and say, where'd you get this from? Oh, I just made it up.
Sure. Well, the
Versus,
value
oh,
of
here's
it
all the
is
data.
the analysis being applied to verifiable data.
Right, but
The statistics.
Right.
right, but the data is still important to make sure that the verifiable,
Absolutely.
the
Absolutely.
analysis is accurate.
Just as for a non-commercial purpose for a newspaper, getting data from police reports and other public documents is important in a newspaper article.
Newspaper's not selling that report to me, it's just selling
Selling the newspaper.
It's selling the newspaper.
The same way that R3 is selling the report.
Yeah.
right? I mean, the newspaper is not taking the public documents and saying to people, here, we're going to sell the documents to you so you can go read the police report. They're selling a newspaper article, which is people, doing analysis of the reports and summarizing them and the like, and that's exactly what R3 is doing here. There's no difference whatsoever.
Are you suggesting then, counsel, that the newspapers, when they go down and make a public records request, are provided those documents for non-commercial purposes?
Absolutely, Your Honor. Unless, somebody from the sales department were to go down and say, we want, these numbers so we can solicit people for, subscriptions. That would be a commercial purpose. But as this court held in Star Publishing and has been held in other places, a newspaper acting in its role as, as gathering information as a news media is a non-commercial purpose. And that's exactly.
So apply that reasoning applicable to a newspaper reporting to the public so it can sell its newspaper.
Absolutely.
To a company that's actively soliciting clients and getting information it can use to sell to clients for use in a case.
Well, Your Honor, the newspaper solicits subscribers, and they sell the newspaper to subscribers, or they now sell it online.
Presumably the
no
subscribers don't come to them and say, if I want to buy your newspaper because you're going to have a report from the Pima County attorney analyzing its data.
Well, people buy it for all sorts of reasons,
right.
But they're going to buy it if they think
anyway.
if you provide good coverage of the police department, and that's going to be based on public records.
They're going to buy it for the obituaries and the real estate listings and the.
I could introduce you some circulation people who might say otherwise these days, but
that may be true. Or they put it online.
But what about Mr. Flagg's argument that this last sentence of subsection D ought not to be amended by us in a way that helps your side?
Well, Your Honor, what they want to do is add two words to the statute. First, they want to add the word admissible to evidence, and that's not in there. And as the court discussed earlier, all sorts of things can be considered to be evidence. It doesn't have to be admissible. And the statute then talks about that it could be used for the discovery of evidence. So that could be anything.
Research for evidence.
Research for evidence. So research for evidence could be anything. And it obviously doesn't have to be admissible at that point. And as far as adding the word pending, there's nothing in the statute that would suggest that. And the legislature, as we pointed out in our briefs, has recognized that distinction and added the word pending about 7 or 8 different places throughout Arizona statutes what it means to do so. Here what's going on is that R3 is amassing a database, and that when a client, whether it be a defense attorney or somebody's concerned about being prosecuted or they're using it for a sentencing report, they generate the report for that action. And whether it's an action or it's a contemplated action or somebody is concerned, for instance, the problem that the court was bringing up about, the county attorney inquiring about what the use is for. Say somebody is concerned that they're going to be indicted. And, they want to know, what are the possibilities that I'm facing here? R3 here could do and say, well, these are the possible charges. They would be working with a defense attorney. These are the possible charges you would face, and these are the possible outcomes. And that's important information to somebody. If you have to go to the county attorney's office and say, well, we want this information, even if you don't say who the person is, you're providing them information that somebody out there, and they can probably figure out some reasonable possibility who it is concerned about getting indicted. So, that would be important information that a defense attorney would certainly not want to disclose to the county attorney's office. Of
course, the way the language of the statute is worded now, it almost makes it like an honor system, when you accept that argument. In other words, a party can come in, a requester can come in and say, I want the following data.
Mm-hmm.
Not say anything.
Sure.
The client actually said what they wanted
If
to
it's for non-commercial purpose, you don't have to say anything.
You don't have to say anything.
Right.
It's just, please give us the following data. And in essence, doesn't have to do anything else.
Well-
And if the county attorney says, I want more information, it could decide, the client could decide, I'm not going to give it to you.
That's
Hand
correct.
over the documents, and then you get involved in a lawsuit about whether they should hand over the documents or at what cost, at least at what cost it is. So essentially, it is a conundrum for public agencies,
No.
because they sort of like, well, how do we determine this? Do we take them at face value? Do we start asking questions?
There's other part of the statute, Your Honor, regarding commercial purpose, and that is, if it's for a non-commercial purpose, you don't have to say what you need it for.
Right.
If it's for commercial purpose, you need to say, this is for a commercial purpose.
Understand that?
Okay, and they're entitled to some degree to ask to see if it's too burdensome to whether they then want to go get an order from the governor to prohibit
For a commercial
production.
purpose.
If for commercial
But
purpose.
If you come in and say nothing,
If I come in and I say nothing and it's for a commercial purpose and I don't tell them that, they have a remedy. If it turns out that I'm using it for a commercial purpose, they can bring an action against me and get as a treble damages.
hope they win.
Well,
Because if they don't win, they can get hit with attorney's fees.
so that could take up a long time talking about our whole legal system here, but they do have a remedy under the statute.
We don't have enough time for that.
But the legislature has come up with a process here, and so if R3 or anybody else were to do this for commercial purpose, and they say, wait a second, you're sending out letters to people and you're soliciting them, or you're selling the raw data that we gave, and you're making a profit on that, they would have a remedy here.
But it's a burdensome, it could be a burdensome remedy. But it seems to me that, I will tell you that my thinking is that if it is a burdensome remedy, then they should be going to the legislature
Absolutely.
saying, listen, we really need to update the statute.
I mean, if they want to add words to the statute, they can go to the legislature and do that. I mean, Your Honor, at the bottom, what this is about is they want to pass along more of their cost in producing public records to the requesters. I get that. But if they want to do that, the place to go is the
It's not
legislature.
necessarily just their costs, because it can be based on the value of the data in the open market. So if R3 were making $1 million a year using
If
this
only
data-
that were true.
If only that was true, that's right. If, I've heard that.
How much are they making?
Then the county attorney could say, hey, that data is worth half of that.
Yeah,
Because the
but I mean-
analysis is really just sort of confusing.
But in the way, we're talking in the abstract here because it's the value of the raw data, and nobody is selling the raw data here. I mean, and that has to be the crux of their argument for this to be a commercial purpose. R3's not selling the raw data to anybody.
They would provide it as part of the report if they requested it.
Well, you're not getting, as I say, they have like 500,000 records.
Right.
What the report you're going to get is, I've been charged with shoplifting, and a first-time offender, what it's saying, and they say, okay, here are these 50 different things in your jurisdiction where,
Client wants, let's say you want to use it for a sentencing hearing.
yeah,
And if the client says, boy, I want to get this stuff into a sentencing hearing for a first-degree murder case, it's going to probably want the backup data that supports the analysis.
of course.
Okay.
Just like, when we talk about other commercial uses, whether it's a newspaper or a book or anything else. Sure. Yes,
Counsel,
Your Honor.
Yeah, I have a question for you. Going to the procedural aspect of what our ruling might or might not be, it's been suggested that some words need to be added to the language of the statute, right? Words like admissible or pending.
Well,
or-
Pima County has suggested that, correct. And I say their argument is dependent upon that occurring, yes.
Is there any support for the notion that those words would bring the language of this statute into the context of what the legislature intended when they drafted it? Or would adding those words simply make it easier to apply and more understandable and those sorts of things? Do you understand my question?
Yes, and I think guessing what the legislature did is, what they intended was their language here. And was the, and they set out the scheme here for commercial purposes and saying if there's any doubt, if you do have a commercial purpose here, but you're using it for evidence or research for evidence in a judicial or quasi-judicial action, then, you don't have to pay the commercial fee for that.
So the bottom line is we really couldn't change it and say that's what the legislature intended. We'd just be saying they didn't get it right the first time.
Well, I would say they did what they intended to do, Your Honor, and they provided the scheme here of if it turns out not to be a commercial, I mean, that we misrepresented what we were doing and it's actually a commercial purpose, they have a remedy. They may not like the remedy, but they have a remedy.
So your argument, I guess, in response to Judge Jones, is you're saying that it is a hazardous to go beyond the language of a statute to figure out what the Arizona legislature may have thought? Is that what you're hinting?
I think we can all take judicial notice and everything else of that, yes.
Wanted to make sure.
Yes.
Okay. Just wanted to make sure and clarify what you were saying.
Your Honors, if you don't have any other questions, I turn over to Mr. DuPont, yes, I'm sorry, to talk for a few minutes.
Sure.
Thank you.
Mr. DuPont, I gather you're both a lawyer and a party.
I'm a defendant. I am, and luckily I have good company with Mr. Robertson, who is one of the most esteemed investigators in the state. So I'm happy to be here with him, and if it please the court.
Do you have a law license?
Do I have a law license? For 23 years. It's my first time here. I never imagined that this is what would bring me here.
You probably never thought you'd come up here as a party.
I did not.
You especially didn't think you'd be here at 4:30 in the afternoon. But
No, and especially because all we wanted was a list of cases.
Yeah.
That's it. We wanted a list of cases that we already had from the clerk of court in Pima County. So to get here on that basis was
you
perplexing.
needed some more data about each case, I gather.
Well, no, they changed the database there
Oh.
in the software they used at the clerk, and we just needed to make sure we had an inclusive data set. So here's where we agree with the county attorney. That list itself has no evidentiary value. It's got no commercial value. It's got no intellectual value. No way in the world we could present that to a judge in court and say this is evidence of anything. We paid Mr. Robertson for his time. That's it. A lot of the issues have been well briefed. I want to get back to the procedure with what happens when we make that request for particular data. Because the statute is clear that when we request any public record and not give any reason, the county attorney's duty is to produce it. The only thing they can do is charge us for copies and postage. That's what the statute says. If we misuse the data, they can seek remedy from us, instead of what happened here. The county attorney has suggested that the standard should be that if I get paid for any reason and we use the list in any way, or that list appears in anything that we do, any final product, that it becomes a commercial purpose. That cannot be the standard. Star Publishing tells us that's not the standard. The troubling thing from our perspective is when, in their reply, appellant says that they believe more discovery is necessary to determine the purpose for which I seek the records. That was in their motion for summary judgment to withdraw their cross motion. They claim on page 18 that they've never asked for any work product, but right on page 16, they say that the appellee would need to produce evidence about what the final product would be made up of. In their uniform and non-uniform interrogatories served on R3 and Mr. Roberts, they asked for the client, case name, status of case, whether any previous analysis had been prepared for any case, whether any previous analysis had been used as evidence, how they prepared the analysis, and then they actually requested R3 to produce all these reports they'd prepared, all these analysis they'd prepared, whether they'd been introduced or not.
Mr. DuPont, our clock time is up, but we'll give you a few more seconds to sum up, if you would, please.
Well, our request today is very simple. Your Honor, we want you to affirm the decision of Judge Brain. We want you to affirm the statutory structure on what the county attorney is supposed to do when we make a request. It's very clear in the statute and what they should have given us right away instead of waiting 6 months to give it to us. We want you to affirm primary consultants, and most of all, from my perspective, I hired Mr. Robertson to spend a couple of hours to do this. He could have stood to made a couple $100 getting me a list that we could use to analyze and make a very important, what I consider an important public analysis of what's going on in Pima and Maricopa County and murder cases. After countless hours, uncompensated hours, and upwards of $60,000 in attorney's fees, I'm asking that you reaffirm the attorney's fees on his behalf.
All right, very good. Thank you, all three of you, Mr. Flagg and Mr. Barr and Mr. DuPont. We appreciate your arguments. You've made good arguments. We'll take the matter under advisement and issue our decision in due course. Thank you very much.